I think we can start. So hello, everyone, and a very warm welcome to this YMP event on securing and enforcing claims in Latin America, which is hosted jointly with Kincaid and Preston Turnbull. First of all, thank you very much for Preston Turnbull and Kincaid for putting such an event together, and to all the speakers with enthusiasm, passion, and I must say a lot of work. It is a real pleasure from my side to see colleagues joining us today from a number of countries, including Mexico, Argentina, Brazil, and the UK. And we are very honored to host such an international event, which gives us an excellent opportunity to exchange views, but also to create and strengthen our international network. And now I will introduce our moderators for today. We have two moderators, Elizabeth Turnbull, and Lucas Leite Marques. Elizabeth is a founding partner of Preston Turnbull. Most of you will know Elizabeth very well. Her core practice focuses on cross-border transportation, trade, commercial, and insurance work, with an emphasis on contentious matters. Elizabeth is a native speaker, a Spanish speaker, and has a wealth of experience in dealing with matters with Latin America. Elizabeth is also the vice president of the IIDM, the Ibero-American Maritime Law Institute. And for Lucas, this is the second event we host together with the YMP. Is a friend, but is also a colleague. Is the managing partner at Kincaid Mendes Vianna Advogados, Brazil. Lucas leads the firm's Sao Paulo office. He specializes in maritime law as well as oil and gas. And of course, his core practice is litigation and arbitration matters. Luca is also the president of AIJA, which most of you will be familiar with. And now, just on a practical note, the topic today, I'm sure will definitely create a lot of interest in the audience. So for questions, so we suggest that you raise your hands and then we deal with the question at the end. But this can definitely be dealt during the session. So if you feel you have any comment, raise your hands, and at the end, we will deal with the questions in order. And Lucas, without further ado, I shall now pass this to Elizabeth to start.
Thank you so much, Francesca, and thank you to the YMP for this opportunity to co-host together with Kincaid. The enforcement of awards in foreign jurisdictions is an issue which is of particular interest to legal practitioners in the UK, where I'm based, as well as parties who have agreed to resolve their disputes in London. Due to the privileged position London retains in respect of international maritime arbitration proceedings. According to the LMAA statistics, there were no less than 440 or so awards that were published by LMAA tribunals in 2023 alone. When a dispute is entrusted to us as lawyers, we need to keep our eye on the prize and ensure the success of our client's claim. But we must never lose sight of the fact that success in this context is not just obtaining a favorable award in arbitration. No, success is ensuring that our client gets the claim paid. Clients are rarely after a Pyrrhic victory. Usually they want to see the money. Now, if we have done our job properly and we've kept our eye on the correct prize, then early on in the dispute, we will have ensured that we've investigated the assets of the opponent company, and if at all possible, we have obtained security for our client's claim, under which payment is triggered by the publication of a final arbitration award. But this is not always possible. It may be that the chance to secure the claim has not arisen before the award has been published, or it might be that the clients were unwilling to go down that route until they felt that they had no other option. In these circumstances, and now armed with a favorable arbitration award, we need to look at enforcement. And here we will need the help of lawyers in the jurisdiction where the debtor has its assets. In this session, we are going to look at the prospects of recovery in Latin America, Brazil, Argentina, and Mexico in particular. In my own experience, enforcement in Latin America is showing a trend towards uniformity in treatment, and the right result is usually reached. But each jurisdiction has its own nuances, and sometimes unexpected results can be reached. Lucas, I believe you have a case that you would like to talk to us as a point of illustration.
All right, thank you, Elizabeth, and thank you, Francesca and Gerard. Thank you, YMP, and all the participants. Happy to be here with you guys today. Indeed, I would like to bring you, those cases where things did not end up well are some of those that will mark us the most. So we have plenty of cases that everything went really smoothly and enforcement could be made, but this one case I would like to pinpoint as a warning, even though our maritime and arbitration team and I think the maritime and arbitration community in Brazil does not actually agree with the results from the court, but actually it is there, it is stated by the court, and a concern should be raised in that regard. Basically, the case I bring to the table is involving the vessel Happy Dynamic. Vessel was on charter, and charter was being negotiated between the foreign charterer and a Brazilian party, and the operation was duly performed. The negotiation was all made via telephone and exchange of emails. There was a setting, fixture, recap through the email. The charter agreement was made through a BINCO form, so everybody fully aware of how it works out. And this was exchanged electronically. The parties all agreed, but it was never printed and signed, as normally it is not, right? So the case happened that after the operations went everything well, there was a piece of discussion in terms of detention and demurrage because of a bit of a delay. And that was the main point of dispute between the parties. This dispute was taken to arbitration in London as provided in the BINCO form, in the charter party that was negotiated between the parties. The award was not paid, and then the foreign entity decided to bring that to enforce it in Brazil. We have an enforcement procedure that Paulo will briefly comment a little later during our debate. But in the end, and the outcome I would like to bring to you guys, it's quite surprising, is that the Brazilian Superior Court, who is the entity entitled to grant the exequatur or not for the foreign award, did not accept to grant the enforcement in Brazil, basically saying that even though the contract was entered between the parties and was duly performed, the arbitration clause that was there was never signed and formally agreed upon by the parties. And basically the Superior Court was demanding that the arbitration clause should have been signed and agreed in writing expressly following the Brazilian Arbitration Act, and did not consider the fact that it was exchanged between the parties by email and in writing, and that Brazil is a party to the New York Convention. But then I am already entering a bit in the comments of the case, which I would like to leave it to our guest speakers. So I will not develop this further. I will leave you guys with the surprise, and I would like to address then the beginning of our debate. We have as speakers Maria Belén Espiñeira from IT&L Legal Consultants in Argentina. We have Paulo Henrique Reis de Oliveira from Kincaid Mendes Vianna Advogados in Brazil, and José Luis Vega Garrido from Ramirez, Gutiérrez, Azpe, Rodríguez-Rivero, Hurtado in Mexico. Having addressed the speakers, I would like just to bring the word to Maria, because Maria, I've heard that you had quite a similar case in Argentina that is worth for you to bring here to the table. And I'm going to ask you to comment a little bit and perhaps add if Argentina is a party to the New York Convention, and if there would be any other domestic laws in Argentina that we should be concerned about when it comes to enforcing a foreign decision or a foreign award there in your jurisdiction. Please, you can have the word.
Okay, thank you. Thank you very much, Lucas. Thank you very much, Elizabeth, Francesca, and to the organizers of this event. I'm very pleased to be here and to have this opportunity to share some experiences and concepts about this practical and interesting topic. So I'm very thanks for that. And going to your questions and the case you have just commented, yes, as we have talked before, while we were planning this seminar, indeed there is not only one case, but that the same approach was taken by Argentinian courts. One of those was referred to a vessel called Ice Sea. The courts interpreted it was a HENCON contract which contained an arbitration clause as well. And going to the point that interests to us, finally the courts decided that interpreting the New York Convention, that Article 2 of the Convention, which refers to the requirements that the arbitration agreement should have, should be indeed in writing. But it says that when the convention says in writing, it also includes the exchange of any kind of messages. It could be in writing or even though in different electronic means as well. So in this case, it was decided that the arbitration agreement was not reached because it was agreed according to the claimant orally and tacitly by phone by the party, and Argentinian courts considered that that didn't suffice the requirements set forth by the New York Convention and considered that it was not valid.
Thank you, Maria. I thought it was only the Brazilian decision that was a bit disappointing, but I'm not happy to see that in Argentina you face the same difficulties. And I was hoping maybe, José, you can bring us some better news from Mexico. Any words on that respect?
Excuse me, it was not that bad. And the different thing is that they interpreted the New York Convention and they said that the exchange of messages could have worked. In this case, it didn't happen because the agreement was reached orally. But any kind of exchanges between the parties should work.
Should work. So it's better than the Brazilian outcome.
Better than the Brazilian part, but it's something important to highlight to our colleagues and the audience that arbitration agreements or the arbitration clause to be valid in Argentina has to be expressly accepted by the parties in any way which could be demonstrated later on. Yeah, and then we go to the other question that if we are party to the New York Convention. Yeah.
Good, it's good to know. And José, what about Mexico? Better news?
Better news, but not so better as the ones you like to hear. First of all, Mexico has been a part of the New York Convention since 1971, so it's a long time ago. And the domestic laws regulating the enforcement of foreign arbitral awards or arbitration awards is the commercial code. So here in this commercial code, you will find the entire rule regarding the request and the procedure that needs to be followed. However, in Mexico, of course, we are also tend to be quite formalistic. It will not be enough, the exchange of written documentation or, messages regarding the acceptance of an arbitration clause. In our case, the contract must expressly contain the arbitration clause, and it needs to be signed, either physically wet inked and each party having one set of the contract, or electronically signed. In this case, the electronic signature needs to fulfill every single requirement contained in the commercial code. And this often creates some confusion among other colleagues or other parties abroad, because they think that with signing a PDF and scan it and receiving a scanned signature of the same PDF will suffice, and this is not the case. So we follow the model law from UNCITRAL regarding electronic signatures. So we need to have all those formalities in order for the arbitration clause to be enforceable here in Mexico. And second, this arbitration clause must be completely clear and must not contain any defect that could affect its validity. Because people here in Mexico tend to argue the validity of the arbitration clause in order to try to make the judges enforce or analyze the case locally, which of course is not the will of the parties at any time.
Well, I have to say it's quite surprising to hear this, because if you have like a contract that is subject to English law, then it's not really required for it to be signed, as well as the arbitration clause being in writing. So this is something that needs to be considered early on, I suspect, in proceedings.
Can I comment on some?
Of course.
Taking the comment that Jose have mentioned about electronic documents, just to point out that in Argentina we have the legal equivalence between holographic signature and electronic signature and digital signature, and also the legal equivalence and functionality between paper-based documents and electronic documents is fully recognized by several bodies of provisions. Civil and commercial code, the specific laws, and so on. In respect of that it's something that will depend on evidence later on, but there is express legislation which expressly recognize the validity of electronic documentation.
So some good news. That's great. So if we return to Brazil, and here I'm going to ask Paulo. We heard from Lucas when he was talking through his introductory case that in Brazil there is a formal procedure for the enforcement of foreign judgments or awards. Could you talk us through what the process is and what the legal requirements might be?
Yeah, of course. Thank you for the question. First of all, I want to say that I'm pleased to be here. I want to say thank you for the kind invitation, and a good afternoon, a good morning, or a good night to those that are watching us. And first of all, we are facing a huge challenge, that is to consider the different jurisdictions when we are formulating the contract. And this is really hard to handle, because sometimes we don't know in the time of the contract it's made where you need to enforce the decision. But to receive the extraterritorial, that is to be valid in Brazil, all the foreign decisions, even when they are judicial or arbitral, we must follow a specific procedure that is made before the Superior Court of Justice, and there are formal requirements. And in the formal requirements, there is the need of a public power of attorney. These need to be under the apostille procedure or notarized. Also, there is the need to present the original court judgment or the arbitral award, and this must also be legalized and apostilled in the country that it was issued. And now with the apostille convention, we have few facilities comparing different countries, but we still have some jurisdictions that we need to face the notarization and the legalization procedures before the consulates, and this sometimes takes longer. After this, there is a need to translate this document with a sworn translator recognized in Brazil. So needs to be a professional under the Brazilian law. And also those are the material requirements, the documents that to be presented, but we cannot forgive about the formal requirements that sometimes create big issues that needs to be solved. First, we need to prove that the decision or the arbitral award was issued by a competent authority. So there is a need to prove how the arbitrators were chosen, how the court was assessed. Also, there is another need to prove the regular summons of the parts, even when the judgment is in absentia. That is, if the part do not present itself in the procedure, we need to prove that all the requirements to try to summons this part to communicate about the proceedings were duly taken. And sometimes this is quite hard to prove, because the opposing part can allegate that something was not done in the right time, because different from other countries. In Brazil, the opposing part, the defendant, they have a deadline to present their defense, and it's even improper to call a defense, because it's not a kind of a procedure that you need to defend something. You need to check if the requirements are achieved, but this happens quite often when the part trying to avoid the enforcement of the arbitral award in Brazil, they allege without proving that something was missed during the summons, or the part was not very well communicated or not properly communicated. And also there is a need to prove that the decision is effective in the country that it was issued, and it must not violate the Brazilian res judicata, and must not contain a violation of public policy. And there's something that we're going to discuss later. It's really hard to be precise about this, because there is no a regular definition of what is public policy, and considering this time frame to present a defense, this can be something really hard to handle. Usually the procedure just takes 5 months, but if the part presents a defense trying to allegate other formal requirements or trying to review the substantive law, this can takes longer. So if the opposing part understand that the procedure is not the time to avoid the measures, but just to check the formalities, the procedure is quite fast. And in this last year was just five months, but in some case with defense, it can last us until 3 years.
Okay, quite a difference. Jose Luis, do you want to tell us, is it similar in Mexico, or are there any differences?
It's rather similar. However, here in Mexico, of course, the documents need to be translated into Spanish, not to Portuguese. And here, the judge gives the opportunity to the opposing party to present any objections regarding the award that was granted against their interests. And it's also an interesting thing that our local laws and our local judges follow or mirror the New York Convention. So the arbitration award needs to be valid. They also analyze if the parties are capable of not, or were authorized or not for being present at the arbitration panel. If the parties were served correctly, in case we have an in absentia party that lost, and that the judgment or the arbitration award deals with the basis of what the arbitration was brought for. So this is an important difference, because then the judges analyze all of these situations and determines whether the arbitration award is legal or not. But also we have some provisions here in Mexico regarding what arbitration awards can deal about. So they cannot deal about any sort of criminal liability, even if we started at a commercial complaint, taxes, personal and commercial bankruptcy, any labor dispute, any conflict regarding the territorial waters of Mexico or the exclusive economic zones. And of course, if the arbitration award will be against public policy. But perhaps we can discuss this. Further on.
Mm.
And the arbitration award, of course, can be enforced in the same manner as a domestic court judgment.
Okay.
Provided that we've got the help of the judges.
Of course. And how long does it take?
It takes around 6 to 8 months, depending on the other parties and if they are cooperative or not. If they are rather contentious, that we could expect up to a year.
Okay, thank you so much. Maria Belén, do you want to tell us about Argentina?
Yes, it's well, it's very similar to all the things that have been explained by Paulo and José Luis. Argentina is indeed a party to the New York Convention and also to several regional agreements which would apply among Latin American countries and also in Mercosur if the proceeding involves an arbitration award which was given in some Latin American country. There might be other conventions to take into account, but all of them follow the same criterion. The idea would be to check if the due process has been followed and if there is no matters of public policy which have been affected, or if there was not any matter which can be settled at arbitration. More or less, the local courts will check those requirements. And there is also a national law on international commercial arbitration, which was enacted in 2018, which is indeed very important because it follows the UNCITRAL model on arbitration law, and it applies to international arbitrations which have seats in Argentina, but also to international arbitrations which have seats abroad in those aspects that are not defined by the New York Convention. They have specific provisions which apply with respect to precautionary measures. That's very important, have a significant practical effect if we talk about later on. And but now the proceeding is similar. It's adversarial as well. It follows the rules which govern the ancillary proceedings. So all deadlines and notifications are reserved for very short periods, 3 days, 5 days. The period to produce evidence is very short as well. And if everything goes smoothly, we can expect to have an award enforced in 6 months. If we have bad news and a complicated counterpart, this may take 1 to 2 years. And what is something important to highlight is that the proceeding doesn't finish when the award is recognized. Then we have the second stage that is enforcing the award. So the duration of that stage will very much depend if we have a counterpart who is happy to pay or who will start trying to hide assets, and then we can check. There are some public registries on movable and non-movable assets who can provide you information about the assets of the debtor, and then you can enforce precautionary measures, injunctions, attachments, and we don't know how long that can take, but well, in the ideal scenario, let's say 6 months, in the worst scenario, but with a positive result at the end, if there are assets from where to collect the amounts due, we can be speaking about 2 years, 3 years. It very much depends on the circumstances.
Thank you so much. So actually, if it goes smoothly, it seems it's quite a fast process in all 3 jurisdictions. That's great. I noticed that you're all very desperate to talk about public policy. So my next question is going to be about that. I'm going to start with Paulo. Can you talk to us about whether there's a public policy requirement in Brazil, and does it encompass matters of substantive law, or are we just talking about procedural deficiencies?
Okay, Elizabeth, thank you for your question. And public policy is something that we don't want to talk about, but we need to talk about, especially because every time that we talk about different questions raised, and is really difficult to precise which is the concept of public policy under the Brazilian law, even in the national procedures, those that don't have any internationality, public policy still being something really hard to handle, like the matters that José raised in Brazilian law, they are under the public policy and definition, so we cannot recognize, enforce, or give exequatur to an arbitration award handling with tax matters, just if we have a bilateral agreement or even other matters. And also it's important to consider that Brazil is part of the New York Convention, and we also have a national law, and this is kind of a problem when we consider public law, policy or national law, because sometimes the judges apply or arbitration law as a public policy matter, and they forget to consider that the parties formulated an arbitral agreement under the jurisdiction that the proceedings were done. So they sometimes don't pay attention and enough to consider that can be even impossible to manage the different requirements from different jurisdictions regarding the arbitral agreement. These need to be valid in the jurisdiction where the proceedings were conducted. But we have several works regarding public policy, several studies in Brazil, and from all those studies, I want to highlight 5 points that I consider important when one part in the beginning of the arbitral proceedings in their jurisdiction, they think that these must be or need to be enforced in Brazil. And also we need to consider we have the same two-phase procedure that they have in Argentina. So we start with the recognition, and then we start the enforcement as we do with any court decision. So the first phase time and how long it takes is very important to be fast enough so the assets is still available and we can recover the money or take the measures that are needed. The first point that I want to highlight between those 5 is the decision, the arbitral award or the court ruling must be well-founded. There is need to be an explanation, a close connection between the reasons, the documents, and the measures that are taken. There are some jurisdictions that this is not an obligation, and even on some arbitral procedures, the arbitrator don't need to do an explanation about how it considers each of the documents. And under Brazilian law, this is quite important in order to avoid the other part to affirm that this is against public policy because it's not very well explained, the connection. Also, it is necessary to avoid punitive damage or damage without a reason. They need to be reasonable in the value, in the form that they must be paid. So this is also another point that must be considering how the parts can address this in other jurisdictions. These also depend on the pledges that we do in our arbitration proceedings. Also, if there is any legal action on the same topic or regarding the same issue in Brazil, is important when you ask for the executor to explain the difference between those 2 proceedings in order to avoid the res judicata. That is something that is also under public policy, and we see cases that unfortunately, just because there is another case in Brazil with the same parts, the court consider that this must be discussed in Brazil, so it's not possible to enforce the arbitral award due to public policy. And when you go deeper into the case, there is a huge difference between the issues that are being discussed in this case. The fourth tip that I wanna share, the document that appoint the arbitrators must be formal, not be oral. So even in ad hoc proceedings, it's important to have a paper or email or something written that can prove how the arbitrators were chosen, and if the other part does not participate in this part of the proceedings, this need is even more important, so we can prove that the proceedings were well done, and with the opportunity to the other party also contribute to the appointment of arbitrators. And this is quite nowadays one of our biggest challenges, because there's a lot of ad hoc proceedings, and we know that ad hoc arbitration is very common in maritime law, that the appointment of the arbitrator is not very well explained in the papers that also must be legalized and translated into Portuguese here in Brazil. And last but not least, as I said before, we need to prove in a satisfactory manner that we tried everything that is possible to summon the other party. That's quite important, because there is also an open gate to those that wanna avoid the obligation to pay or the enforcement of the arbitral award in Brazil. So between a lot of different definitions, I think those 5 tips can help us to enforce the arbitral awards in Brazil in a way that this can be effective and also be fast, because it's worse than losing a case is winning a case and you cannot enforce due to any formal requirement.
Thank you, Paulo. Maria Belén, do you want to tell us about Argentina? Is it similar, or are there any material differences?
No, it's similar. It's very clear that the courts cannot go over neither revise the merits of the case. They cannot go over or revise neither the facts nor the legal findings. That's something that is reserved to the arbitration jurisdiction and shouldn't be gone over by local courts. What local courts will basically check is if and consider public policy if the essential elements that our legislation, formal elements if the formal elements or procedural aspects that our legislation considers essential for the proper administration of justice are complied and respected. So it's more procedural, and of course they will never recognize an award that goes against the public policy by interpreting it as those fundamental rights on which the Argentinian society is built, and those that cannot not be waived in any way by the parties. It is definitely more a review of the procedural aspects in order to guarantee that the due process and the right of defense was respected. And there is no public policy, but as a matter of fundamental law that are breached. And it was clarified in a judicial decision that the ones who allege that public policy is infringed cannot allege generic principles that the public law is generically or in broadly terms breach. It has to be very accurate evidence demonstrated in a very concrete case.
Thank you. José Luis, what about in Mexico?
Well, apparently Mexico is like a Frankenstein between Argentina and Brazil, because we've got, the definition of what is considered as public policy in our commercial code, but just in a couple of lines. So it left it to the interpretation of the courts, what it can be considered as a public policy. And, given our nature of trying to get around this kind of arbitration process, because sometimes they are not convenient to the parties, or to the losing party, then the courts started limiting what can be considered as a public policy. And we are down, or we have been narrowing it to 5 concepts, the violation of fundamental rights, the acknowledgement of our constitution, any fraud or corruption, due process violations, which Paulo explained perfectly, and any contradiction with Mexican law regarding what we call public interest. And this is analyzed on a case-by-case. Because here in Mexico, there are entire laws and acts that are considered as such. And I will give you a dumb example. We have something that's called the Monetary Act of the United Mexican States. So for instance, if a debt needs to be paid in Mexico, it cannot be enforced in foreign currency. So for instance, if we've got an arbitration award that says, hey, you must pay in dollars, in euros, but the payment is going to take place here in Mexico, then the paying party, the debtor, can solve this obligation using the exchange rate published by the Bank of Mexico in the official Gazette of the Federation on the date on which it pays. So that's a huge, maybe it's a huge difference between what the creditor is expecting and what the debtor is actually going to pay, because we have fluctuations because of the exchange rate. But another example, narrowing to what we do, for instance, in land transportation. In land transportation, if the value of the cargo was not expressed in the way bill, there is no way that the transportation company is going to be liable for the value of the cargo itself. It's limited to a certain ridiculous amount in the local laws. So that's what we consider as public policy. And there is a precedent from our collegiate courts stating that the courts receiving an arbitration award need to be analyzed by them, because these decisions cannot contravene any of the points I have just mentioned. But the Supreme Court of Justice, on the other hand, has been limited more and more the public policy excuse for not accepting an arbitration award. And a simple example can be that public contracts entering into by and between the government and a private party can be subjected to arbitration, and public policy cannot be argued by the Mexican government as an exclusion because it's just the government. So they are bound by the arbitration and by the arbitration award issued by in an arbitration with due process.
Thank you. Maria Belén, you have your hand.
Yes, because Jose Luis had mentioned something that brought light to my knowledge, and I would like to comment or to add that when I mentioned that those rights which are considered public policy and cannot be waived by the parties voluntarily, in respect of maritime matters, it's important to highlight that the limitation of liability, for example, it's of public policy. So if there is an award that goes behind the limits as set by the Argentinian navigation law, it will probably not be recognized because that's something of public policy. The same happens in respect of some exclusive jurisdiction, which is expressly provided by the Argentinian navigation law, but we will talk about that in a while, I think.
Thank you. Paulo?
I'll be very fast just to address the limitation of liability. Unfortunately, Brazil don't have any value in the law. We just consider that is against our public policy, the clause that excludes the responsibility. So we cannot accept in an arbitration that recognize a clause excluding the responsibility of the carrier. So considering the value, we rely on the contractual and how this was decided by the parties when they were elaborating or choosing a standard form. But in our law, there is no specific value considering the limitation of liability, although it's very well recognized by our court, specifically when we consider arbitral and foreign proceedings.
Thank you so much. So we've spent about 45 minutes talking about the enforcement of arbitration awards. And I would like to ask you whether the procedures that you have described in respect of arbitrations would be the same as if you're trying to enforce a foreign court decision. José Luis, would you like to answer first?
Yes, thank you very much, Elizabeth. Well, it's a different monster. It requires more formality. Arbitration, deal with commercial things, and, where people are more sensible regarding the decision of arbitral awards. We are, in this industry, we have a culture of acknowledging these awards. However, regarding civil matters, the formalities are larger and more burdensome for the parties. First of all the formal requirements that we have just analyzed, and it will be completely boring to go over them once more. However, here, in these cases, the judges review the authenticity of the judgment and that it constitutes res judicata in the country of origin. So if this is not a final judgment, then this judgment that you have, for instance, of a lower court cannot be enforced in Mexico if it's subjected to be appealed in the country of origin. Then the court summons the parties where they can present their arguments. And this also creates another problem, because what if the other party, of course, is residing in another country? How will it happen? The Mexican government, the Mexican judge will use the consular services of Mexico to notify the judge that dealt with the case about the summons to the foreign party. And this takes a long time. You know, it takes the formalities of the consular process with the rogatory letters and the exequatur's form. So it's quite burdensome, and you know, due follow-up by lawyers need to be carried out. Otherwise, something might get lost. And what happens, because sometimes these judgments include precautionary measures. These are accepted in our country, but you know, they must be binding. And if they are not binding and final in the country of origin, then they cannot be enforced in Mexico, which creates another step to be followed in the country of origin. And of course, other problems and probably more expenses for the creditor to enforce a judgment in Mexico. And of course, the judgment tends to be more or lengthier than an arbitration award. So sometimes you need to accompany with the judgment a legal opinion from a local lawyer in the country of origin if some of the concepts are not familiar with Mexican courts. For instance, we do not have torts in Mexico. So what happens if we have a resolution from a UK or from an England and Wales or Scotland judge thinking, hey, yes, this is battery, and we do not have that concept in Mexico. So we of course require the analysis of an expert that needs to explain this, and they only accept the opinion of a foreign lawyer duly qualified. Then you need to prove that the lawyer is duly qualified, that you know it's an expert on the matter that he or she is speaking of, and translating all of these documents as well, which creates more troubles for one party seeking the enforcement of a foreign judgment here in Mexico. And of course, if we are talking about this, it could take, you know, between 1.5 years to 2 years to enforce a foreign judgment vis-a-vis 6 to 8 months if everything runs smoothly with an arbitration award.
Thank you. Paulo, do you want to tell us about Brazil?
Yeah, and happy to share that in Brazil, the proceedings are the same, but even when you consider a court decision, a court final decision, we need to prove that the authority was the competent authority, and something that is more difficult to prove than the arbitrators. But also we can have the possibility to enforce in Brazil provisional measures, as we're gonna talk later. So the scenario is quite different from Mexico, and the proceedings are basically the same.
Wonderful, thank you. Maria Belén?
But it's different, but it's very similar than the proceeding necessary to enforce the arbitral award. There are also specific international and bilateral treaties that Argentina signed with other countries to facilitate the recognition and enforcement of judicial sentences, but the bilateral treaties are very few. It's just Italy, France, Russia, and China. And there is a regional agreement, the Montevideo one, to which most of the Latin American countries are a party to as well, which facilitates the proceedings a little bit more. But irrespective of the international instrument which could be applied, the procedural codes which could also apply in case we need to enforce a judicial sentence given by a foreign court, it's similar to the one we are speaking in with respect to enforcing arbitral awards, more or less the same.
Oh, thank you, Maria. And if I may step in very briefly, I was happy to see that Jose and Paulo touched very briefly on this, and I'd like to invite you to elaborate a bit further on, we've been talking about enforcing a final award or a final court decision. What about provisional measures, injunctions, or even if it's the decision on the merits, but it's not final yet, still pending an appeal? How would the courts in your jurisdictions face that? Would that be allowed and possible, or would we be barred and just have to wait for a final and definite decision before we can start the enforcement procedure? And that might be too late sometimes. So I'd just like to invite maybe Paulo to start, and then Jose and Maria can add on that.
Yeah, we have this procedure on our civil procedure code. So in Brazil, it's possible to enforce preliminary and provisional measures. And this we do under the letters rogatory procedure. So we can also do this in an urgent basis. And that is something very important when you consider how fast the things are in maritime issues. So in this case, the enforceability, you'll be granted even before the opposing party, the defendant, is heard, if we prove that there's a need to do this in an urgent basis. But something that we must be concerned when you consider Brazilian law is that after the court considered that this enforcement that was granted under urgent basis, there is unfounded, so there is no reason to maintain this decision. The other part must be liable to pay out the expenses that the defendant supported due to this provisional measure being recognized by the being recognized and enforced by the Brazilian court. So this is possible. The formal requirement is still the same, but if there is a way to prove, especially coming from the authority, even is the court of the arbitrator, proving that is something that must be done in an urgent basis, this can be done very, very fast in Brazil.
Thank you, Paulo. And Jose, what would be your views on that?
Yes, regarding here in Mexico, of course, the precautionary measures are acknowledged. However, these need to be clear. And also, we need to bear in mind the differences between the judgment and the arbitration, because if it's in a normal civil case or in a normal case that's before the courts, it needs to follow the consular services and the consular letters, with all the rogatory letters, exequaturs, and whatever not. Whilst from the arbitration award, it needs to be a formal notification from the arbitration court, given to the appropriate courts. And they are acknowledged here in Mexico, and they are enforceable, provided that they do not violate public policy, of course, And because sometimes we've got some awards that go beyond what, they are acknowledged as precautionary measures here in Mexico, and that are not enforceable. But more often than before, now we've seen the courts more often to approve these precautionary measures, such as a specific performance in the time that the arbitration award is being, solved at the country of origin. Because we know that we live in a very interconnected world, that if we fail to supply certain goods to Mexico in instance, you can stop an entire production. And this happened in the past with the prohibition of the importation of some oil derivatives that impacted the automotive industry in the country. So, there was some doubts or what we could as lawyers do in order to protect the production of our clients, at some point. So these kind of precautionary measures are more often accepted. However, regarding the final decisions, they need to be actually binding on the last ones. Otherwise, the Mexican courts will not accept it. And this is something that it's troublesome, of course, for the creditor, because they need to exhaust the entire resources at their hand at the country of origin in order to be enforced in Mexico, and of course to claim whatever they can claim here.
All right, thank you, Jose. And what about you, Maria, in Argentina? How is the situation there?
With respect to the arbitral award not being final, because it's pending of being resolved, because any recourse which was presenting, or if it's not final, it cannot be enforced in Argentina. That's one of the requirements, and it's like that. If it's not final, at least partially, it can be finally it can be final partially, but it has to have conclusive effect. That's one of the requirements to start the enforcement proceedings. So with respect to that is my clarification. And regarding precautionary measures, well, in the new law I mentioned at the beginning, which was enacted in 2019 about international commercial arbitration, is very important in this respect because it brings a lot of light and clarifies a lot what courts can do and cannot do. It's different if the precautionary measure is ordered by the arbitrator abroad from if the precautionary measure is requested by one of the parties to the Argentinian courts. And in both circumstances, judicial courts have jurisdiction to order and enforce these precautionary measures, always provided that they are entitled to order them and that the necessary requirements are met. This legislation expressly states that the parties to an arbitration agreement can, before and during the constitution of the arbitration or arbitral tribunal, request precautionary measures, and that will not be considered as a renounce or as against the arbitration agreement. So that was put very clear in this new legislation, and I said in these aspects applies also to foreign, to the recognition of foreign arbitral awards. And it also expressly provides that courts will be empowered to order precautionary measures to cooperate and secure the enforceability of an arbitration award, which is being resolved abroad. It says express that it doesn't matter if the arbitration tribunal is sit outside Argentina. It says that courts are empowered to order precautionary measures. And of course, precautionary measures are ruled by the law of the place where they are requested. So courts will pay attention to the procedural law to do that. But precautionary measures could be obtained either through the recognition of a precautionary measure ordered by the foreign tribunal, and also by requesting the parties a precautionary measure before local tribunals. It's something interesting or convenient to make clear in the arbitration clause, because not to have surprises later on. If the parties agree to settle a specific dispute in arbitration, it might be convenient to decide if it's desirable or not, to also preclude the parties from requesting precautionary measures abroad, so that the tribunal is the only one who decides on precautionary measures issues.
Thank you. And when you talk about precautionary measures, are you talking about issues like security for claims?
Yes.
Exactly. Okay,
Security
wonderful.
for claim, and also preliminary measures, for example, to gather evidence. If you need evidence that could be useful in an arbitration proceeding, you can also plead special preliminary measures. This law really tried to bring certainty to arbitration and to enhance the attractiveness of Argentina as a friendly forum where to enforce international arbitration awards.
Thank you so much. Okay, and I think I heard you say that these precautionary measures or security can be requested locally, both when the arbitration is progressing itself and also once you have started your enforcement proceedings in Argentina.
Yes, both. Also the legislation, the special law provides cases where these measures can be denied. No, it's not that it will work always. Some requirements have to be met, and these causes of to deny these precautionary measures are related with the causes to reject the enforcement of the arbitration award. So the courts will see, and the parties will need to demonstrate that the due process was not respected, the parties were not duly notified, public policy issues, the other formalities The bad news is that precautionary measures are ordered ex parte. So these objections will come after the arrest will be taking place, and the appeals that could be entered do not have suspensive effect. So the resolution of these appeals will take some time, and during that time, the vessel might be detained if another guarantee was not offered in substitution, of course.
Thank you. José Luis.
Yes, I just wanted to complement that here in Mexico, we also have other kind of precautionary measures which are interesting for foreigners, which is like, for instance, the freeze of bank accounts if we have reasonable expectation of the debtor, to try and, flee the collection of any liquid debt. So as long as in the arbitration award or in the requirement from the creditor is included and justified that the debtor is going to try to diversify its assets or even, liquidate them and then flee, you can ask for this, which is a very nice way of putting pressure to the debtor to pay on time, because if you freeze the entire bank account, they can no longer operate.
Of course, thank you. Paulo, do you have anything to add?
In Brazil, the proceedings are quite similar to the Argentinian procedures, but the judges are being very attentive to the competence principle. So if you ask for provisional measures before the panel of arbitrators being constituted, you have 30 days to do so in order to maintain the validity of the provisional measures, and the arbitrators can review and also can stop the enforcement measures that are being taken as a provisional measures by the court. And also when we consider a provisional measure that is being taken during the proceeding before the decision becomes final, we use the proceeding that is called carta rogatória, letter rogatória, that is different from asking as the recognition and enforcement of a proper arbitral award, but both are important and possible under the Brazilian law. But when there is a party asking for provisional measure during the arbitral proceedings, usually the judges are more attentive and more up to grant if there is a letter or something from the arbitrator in order to respect the competence principle, and also the procedure that is being taken by the arbitrator even in Brazilian seat or in other states. So if there is a arbitrator panel, the best way to do so to have a provisional measure being granted in Brazil is to use a letter or a formal proceeding from the panel of arbitrators to present into the court, because the court can refuse preliminary in order to avoid being somehow interrupting the proceedings or turning this almost impossible to achieve its final objective.
Thank you so much. We're coming close to the end of our panel discussion. Nearly to conclude, a question for Maria Belén. Now that you've heard all the responses and the case study that Lucas explained at the beginning, are there any formal requirements for drafting arbitration clauses in your jurisdiction that one should take into account? And do any issues arise, for instance, if you have a charter party that contains an arbitration clause that is then incorporated by reference into bills of lading?
Okay, regarding the formalities of the arbitration clause, I think we have mentioned a few things before. But regarding the second part of your question, I think it's the most important part of the things I could say in this webinar. And something that has to really be borne in mind is that in voyage charter parties, and bill of ladings and contracts of carriage of goods by sea, where the goods have to be delivered in Argentina, the navigation law provides that Argentine courts have exclusive jurisdictions to resolve those cases, and that's a matter of public policy. and cannot be waived by the parties, except if the agreement is entered after the incident that give rise, that motivates the disputes occur. So one thing to recall is that voyage charter parties and contracts for the carriage of goods by sea where the goods have to be delivered in Argentina, an arbitration clause inserted in the contract or in the bill of lading would be considered null and void by our courts. And of course, that would be a cost which will preclude from the enforcement of any arbitration award, which could be given later on. Extensions of jurisdiction agreements are possible, but after the incident took place, if the Argentinian nationals so decides. This is a matter of public policy, and it was enacted into law after a long-standing judicial history as well. And it intends to protect Argentinian cargo owners, Argentinian interest. So it's a very important thing to bear in mind. And the same occurs in general average contribution claims. Any clause in a contract which precludes Argentinian tribunals to hear cases where a general average contribution is being disputed when the maritime adventure finished in Argentina, or if the general average adjustment or apportionment is made in Argentina, will be null and void due to a public policy issue as well. So an arbitration award in those circumstances will not be upheld.
So that's a bit of a bombshell. So I'm hoping it's only something that happens in Argentina?
Only when cargo has to be delivered in Argentina, and only in voyage charter parties and contracts of carriage of goods to protect nationals' cargo interests. It doesn't apply if the cargo has to be delivered somewhere else, and this doesn't apply to other kinds of contracts for the use of the vessel. Bareboat charter contracts, time charter parties, in those contracts there is no problem with the jurisdiction or arbitration clause. But in voyage charter party and bill of ladings, there can be a problem when the cargo has to be delivered in Argentina. There was a case where the dispute was about some demurrages occurred during loading operations in a voyage charter party dispute where the cargo has to deliver abroad. And one of the parties tried to say that the Argentinian tribunals were the ones who were competent because the cargo operations which give rights to the demurrage disputes occurred in Argentina. And in that case, the courts decided that that is not relevant, that the important thing is where the cargo is delivered. Yeah, so it's only important to recall these issues when the cargo has to be delivered in Argentina. And in general average contributions matters as well.
Thank you.
If I can add something very quickly, in Brazil is quite different. And if I need to answer these questions for you, Elizabeth, and for or those that are watching us, 1 year ago, the answer will be quite different. And if I need to ask, and if I need to answer again, in few months must be something different. Our courts are increasing the recognition of the arbitration clause, specifically if the BL refers to the charter party. And this is under the recognition of the competence, and also the courts are understanding better that the validity of the arbitration clause needs to be analyzed under the applicable law. So if the English law is the applicable law, we need to check if it is possible to the BL just refer under the English law, not under the Brazilian law. And these are increasingly specifically in the lower court and in the state court, is considering how Brazil is a federative country. So this is changing very fast, but we still have in a very difficult situation regarding legal certainty when we refer to the proceedings that are one of the parties is an insurer company, because this is changing in the superior court nowadays, but we still have a lot of cases in the Court of Appeals, in the lower courts, that the courts are not considering that the insurer is vinculated or is binding by the arbitration clause, and this is quite hard because they are analyzing under the Brazilian law and not by the law in which the clause was formulated and in which the party considering when they were building the contract and the business. But this changes, and I hope if we meet again in 1 year or less than this, I will say that in Brazil we have legal certainty, then the position is very well established by the court, but until now we still have to face those different cases, and like we have in case that in the same lower court, different judges decided the opposites, and it's hard that we don't have any procedure when there's two judges from the same court deciding in opposite ways. So it's really a Russian roulette, because they can be the opposite in different proceedings that were presented in the same month and were decided just with 2 weeks between the first one and the second one. But we are doing our best to challenge those decisions and to find legal certainty.
All right, thank you, Paulo, thank you, Maria and Jose, and thank you, Elizabeth, for bringing such a delightful debate. We could spend much more time here discussing these and other issues as well. I enjoyed that we still have some minutes left to take the opportunity and invite the audience here. If you would like to open the mic to present a question or just add a brief comment from your specific jurisdiction, so we'll be more than happy to welcome you to that. And I acknowledge also that we had 2 questions in the chat, one from Florencia bringing a view from Uruguay and another one from Frederico from Brazil as well. So feel free if you would like to address it. And I've seen already that Florencia raised the hand. So Florencia, I'll be happy to open the mic there for you.
Hello, you
Hello.
hear me?
Yes, we can hear you well.
Thank you very much. First of all, congratulations. It was a very interesting discussion. My name is Florencia Sierra. I'm from Uruguay. Just in case, if you're interested in having the position of one more country, we in Uruguay also have ratified the New York Convention. And although we don't have a binding precedent, I have a judgment from our law firm. I think that it was 2013. The Supreme Court considered that the signature requirement was fulfilled by means of email exchanges. The convention says signature or exchange of notes, something like that. And this last requirement was considered fulfilled by means of the exchange of emails by our Supreme Court, and it was very important. And in this case, the arbitration clause was not even expressly included in these emails. It was a contract of sale of goods that the parties exchanged the terms of a contract. And that exchange included the particular conditions, but the general conditions referred to the GAFTA contracts. And these were the ones that included the arbitration clause. And with all these references, our Supreme Court considered that the arbitration clause was agreed between the parties, and the arbitration, the judgment was executed here.
That's good to hear, and I think that goes well with the comment that Frederico made in the chat about contracts involving GAFTA, FOSFA, or other associations in terms of arbitration clauses. So thanks for your insight from Uruguay. And
thank you.
we'll be happy to open the mic if anybody would like to add something. And if I may also add a brief comment from what we've seen. We know it's not always very common and usual, but we as lawyers would always make this comment how important it is to when the contract is being negotiated, to try to foresee the problems and the difficulties even in enforcement, and see if you can have just a brief insight from the different jurisdictions that the contract and the dispute might touch, just to bring that to the table right from the beginning. That could certainly save a lot of headache in the future. And one final comment. Normally, it is not very uncommon to see a Brazilian party not attending the arbitration, a foreign arbitration, simply not joining the arbitration. This is a sign also that the party will probably try to rely in challenging any future enforcement in Brazil and challenging the arbitration clause, and not appearing there could be a strategy to put that to the table afterwards. So perhaps obtaining information and assistance from a local Brazilian counsel at that time could be important to try to prevent that. And I'm sure we would have still plenty of other topics to raise in this respect. I was happy that the topic of enforcement was suggested, and we will of course be more than happy to repeat that again, bringing the views from our own jurisdictions. In terms of any other topic, it is of interest to YMP members. And I would just like to pass the word, if we don't have any follow-up questions, to our speakers and to Elizabeth as well. If you have any final comments, feel free. We still have 10 minutes or so.
Lucas, excuse me, we have another question in the chat. That is wonder the enforcement of English summary judgments, and I will start answering there in Brazil. If there is a full resonance in the judgment, this can be recognized as any other the award is any other judicial decision. So we don't have any problem with this, just we need to consider the public policy regarding if the fundamentals of the decision are very well exposed and explained, and this leads us to a connection between the reasons and the results of the judgment.
It would be exactly the same in Mexico, as long as it is binding and final no violations to the due process or to public policy is found on this case, then you can enforce it here in Mexico too.
All right, good to know. And in Argentina, would it be the same, Maria?
I guess it could be the same, but the extension elements which guarant that the proper justice administration justice administration is given should be filled. I'm not sure what this kind of proceeding is about, but just because on the basis that they claim the defense has no real prospects of success, I'm not quite sure if a proceeding that is reduced because of that could be enforced. The right of defense and to be heard by the parties has to be respected in order not to have a public policy issue. That's
all right, great to hear. If that is, I think we may have another question also here, or comment in the chat. So the question is, before applying enforcement, could the applicant apply for disclosure order of assets of debtors and freezing order of such assets if we found some? Interesting to know. Would you like to add on that? Maybe Paulo, you can start, and then Jose and Maria.
Yeah, I can start, and you can also help me on this one, Lucas. And first of all, it's important to consider that Brazil does not recognize disclosure as a way of obtaining evidence, as we can see in the United States or in the other countries. So in order to have a disclosure of the assets, so there is the information regarding the the declarations to the federal revenue and those other information you need to have before a kind of provisional measure or award that needs to be recognized and then enforced in order to have access to those assets. But if already, but also we need to consider in Brazil, a lot of this information is public. You can go to the notary office and ask if there is any asset that is belong to a person or to an entity, and in this case you can try to, and in the court you probably accept to put in the register of the ship or in the asset, there is a proceeding there can be that can affect the property of this asset. But the disclosure, and I'm not quite sure if you are using the disclosure as we consider the way of having evidence in the US law, this is not accepted by the Brazilian law. You need to use these systems that are provided by the government, by the organism that you can access and have information about the assets.
And it'd be somewhat similar in Mexico. You cannot ask anyone to, to disclose the assets they have. So, and to list them to make, your life as a creditor easier, you need to go to the proper governmental instances to ask for that. And that's why, prevention is the key in this kind of cases. If you have a lien, then go to the public registries. We have lots of public registries depending on the topic, in order to, try to seize any assets beforehand. And before you have the arbitration award, if you know as a representative of a creditor that something is going to go south, and it's that you will need to start an arbitration, try to get a hold of a lien over the certain assets, and try to investigate beforehand what kind of assets this company has. Otherwise, you will be lost in a fruitful but lengthy investigation regarding where you can collect the debt or how you can collect the debt.
In Argentina, it's similar to Mexico. You can obtain, the party will not disclose their properties, but you can ask that information from the different organism that could have it. Of course, we have to check the requirements, if the requirements set for those precautionary measures are met. If they are met, probably yes.
And is this a question that we can ask you as lawyers, or do you need to go to like an asset investigator?
No, there are public organisms who have that information. There are some companies who also have that information as well. They know their movable assets, then their non-movable assets, if they have bank accounts, where, their creditor capacity. You can also pay for that.
Mm-hmm. But can I come and ask you to obtain this information, or do I need to go to another type of investigator?
Well, we work hand by hand with investigators sometimes, because it's sometimes it's difficult, and you need to also be aware that here in Mexico, only an interested party can actually file for an investigation. Although these registries are public, some of them require this qualification of being an interested party to try to obtain the information, especially regarding bank accounts. And at least you have to have some kind of information, for instance, the complete name of the debtor, or perhaps the location of certain real estate. But in the maritime registry, for instance, with the name of the debtor, that would be enough to see which vessels are already registered under its name, or if these vessels are already subjected to any encumbrance or lien. Regarding the public registry for warranties over movables, you can see their shares are pledged in favor of a creditor. So, it's done electronically, so it's actually quite swift. But you need to actually have the guidance of a lawyer, because I'm not this is not an advert, but this information comes in Spanish. And, if someone asks you, hey, can you provide me with the mercantile folio of a certain company? You in the UK will tell me, hey, what the hell is that? Where do I get that information?
And in Brazil, I consider that it's important to have a lawyer to help you on this, specifically consider our data privacy law, because some of companies, they sell and they provide the information that you cannot just present to the court to have something to find a way that you can prove that these were obtained in respect of the data privacy law. And also the lawyer can help you with the strategy in order to prevent those assets to be moved. Our data privacy law is quite recently, so a lot of the banks of information are constituted before, so they keep selling those information. You cannot just go into the court and present, because it can even constitute a crime against the privacy of the opposing part. So it's always good to have a law firm to help on this. And probably and also in Brazil, this is very decentralized. We have 27 states and more the federal district, and there are different notary offices, and we have like somehow to study and to have some strategy before asking to every single notary office, because notary offices in Brazil are quite expensive. So if you do a research about assets in the entire country, this can achieve more than $2,000, and considering a claim, this can be a quantity that is not that high. But if you do this in every single country and against every part, can be a cost that you can avoid during the proceedings. So that's important to have a legal advice on this.
If you are in the enforcement stage, you have more tools how to find assets. You can count with full cooperation of the court to obtain the information you need to find the assets. If you are in the preliminary during the arbitration process, you can count with the judges, with the judicial organs collaboration, but of course you have to demonstrate the periculum in mora, the bonus, fumus in bonis. If there are really risks that the debtor is spending their assets, and you need the cooperation of the judicial courts to eventually be able to enforce an arbitration award, which, subject to the New York Convention, will be enforceable in Argentina, and Argentine courts will cooperate with that and will assist in requesting informative evidence to the different registries and obtain the information you need. And then once the assets are located, enforce the precautionary measures. It will probably request security as well as guarantee of the potential damages that may arise from enforcing them.
All right, thank you very much. And I think with this, we reached the end of our the debate and the Q&A. I'd just like to pass the word to Elizabeth for the final words, and say that we were very happy to be a part of this, and very happy that you could all enjoy as well.
Thank you. And on my part, I would like to thank you, Lucas and Kincaid, for being co-hosts or co-moderators. It has been a real pleasure. Thank you to YMP for the invitation to participate in the panel, and especially thank you for our wonderful panelists, who I think have taught us all a lot. I've learned a lot this evening, and I found it incredibly enjoyable to listen to you all, so thank you. Most importantly, thank you to everyone that has attended and that is listening, and we thank you for your questions and feedback, and we hope to see you at the next event.
Thank you all. Thank you very much.
Thank you. Thank you. Hope to see you soon.
Thank you very much for this wonderful opportunity. See you soon.
See you. Bye-bye.
Bye.